I'm really happy that there are so many people here today. You never really know when you have an event and people will show up, so I'm really glad they are all here. On behalf of the law review, I just wanted to welcome you and thank you for attending the 2018 Browning Symposium on Federal Indian Law. The law review has been working tirelessly since last January to bring you this symposium. And so we're really happy to see all of you come out and support us, and most importantly, learn about an area of the law that's so important to Montana and Montanans. The law review could not have put on this event today without the help of several individuals, so I'm going to read a list here. Particularly, we would like to extend our gratitude towards our advisor, Professor Anthony Johnstone, as well as Professor Monty Mills, who has helped us every step of the way. We would also like to thank the administration of the law school, particularly Sarah Kreiger, who has been very helpful in making sure all of you could come here today. So thanks for all of you for your help with this event. And also, personally, I would like to thank all of the editors and staff at the Montana Law Review, particularly Abby, who's probably still running around trying to get things done because she's been so helpful with this whole thing, and I couldn't have done it without her. And also Victoria Nicole, or Corey, sorry, and Tracy Luther, the editors-in-chief. So on that note, thank you again for attending the symposium. And without further ado, welcome the Dean of the Law School, Paul Burgess, to say a few words on behalf of the law school.
Again for Jennifer. Her and our outstanding group of law review editors. I want to welcome you to the Blewett School of Law here at the University of Montana. This is, of course, a big weekend for us with homecoming weekend, and it's wonderful that we have so many of you here to share this exciting day on federal Indian law with us. And you see from the turnout here today how important these issues are and how much they matter to our community. This series, the Browning Symposium series, is named for the Honorable James Browning, who was a member of the very first editorial board of the Montana Law Review, and went on to be its editor-in-chief, and then went on to serve for more than 50 years on the Ninth Circuit Court of Appeals, including serving as its longest chief judge. And so it's wonderful that we're able to honor his legacy with this series. The series was endowed in 1994 by a very generous gift from John Hirsch that has allowed us to continue this biannual symposium series. It's exciting for us that we can bring together our tradition of the Montana Law Review with our history in Indian law. And we had, many of you know, the very first Indian law clinic in the country under Professor Marge Brown. And that tradition continues with our outstanding group of students in our Native American Law Students Association. We take great pride in fulfilling our constitutional obligation to educate American Indians and to work with the 7 reservations and 12 tribal nations in our state. Professor Johnstone just gave me a really interesting piece of information about the relationship between Indian law and our law review. Since 1960, our law reviews published more than 60 articles on Indian law, and among those were the student notes of our 2 senior federal judges in Montana, Don Malloy and Sam Patton. So this is a very rich tradition that we mine here today. We had a student a couple of years ago, April Uberol, who is a native of Montana, and she's the granddaughter of one of the litigants in a Supreme Court case of Babbitt versus Hughley, and she had a chance to talk to Justice Scalia about that case a few years before he passed away. And in a moment of candor, Justice Scalia told her that when it comes to federal Indian law, the Supreme Court is, and I quote, just making it up. And we'll have the opportunity today to hear from some of the leading scholars on federal Indian law in the United States. And we're really excited to have them here to illuminate for us what is an important and difficult area of the law. So thank you again for coming. We're looking forward to a wonderful day today, and enjoy your time here at the Blue School of Law.
So now I'll just introduce, we have Jordan Sasso here from the People's Center, and he's going to have a little cultural recognition for us and an honor song. Also, just making sure the mic is working, you guys can hear me in the back? We're good, okay. And also, just note, if you didn't notice when you came in, there's breakfast set up outside, there's coffee and water and food, so please feel free to leave or step out during any of the panels and go get yourself some coffee or some water or something to eat. It's there for you, so go ahead and do that. So now I'm going to introduce our first panel of the day, which will focus on civil rights and more specifically civil rights of Indian defendants in criminal law. So this panel includes Professor Barbara Creel. Here, I'll move you. There we go. If you want to put that one up there too. Of the University of New Mexico, who will be presenting her paper on Indian defendants' right to counsel, and the other panelist is Professor Frank Pommerscheim of the University of South Dakota, who is presenting this paper on ICRA and Miranda violations. So we're really lucky to have both of them here, and they both traveled from pretty far. I'm sure you know South Dakota's pretty close, but it's not very easy to get here flying from there. So the panel is also moderated by Judge Brian Morris of the United States District Court of the District of Montana. Judge Morris obtained his law degree from Stanford after graduating. He served as a law clerk to the United States Supreme Court. And then after that, he returned to Montana and was the Solicitor General for the state and also served as a justice on the Montana Supreme Court. So we're really fortunate to have him here today. And he has a special interest in this panel, particularly because his court presides over crimes committed on several of Montana's Indian reservations. So now I guess I'll turn it over to Judge Morris, and we'll get started.
Thank you, Jenna.
Is it on? There should be a switch on it if it's not on.
Said it's on.
Okay.
Is it working?
Yes.
Okay. All right. Thank you, Jennifer.
Yeah.
Nice to be back here. Nice to be in an academic environment. I see a few things haven't changed. I remember college and law school where the back of the room filled up, overflowing, and there were rows and rows of empty seats in the front. We had our district conference recently at East Glacier, and all the employees of the District of Montana get together, the judges, the magistrates, law clerks, probation staff, clerk's office, and we had a number of very informative panels there. We had a long, narrow room with tables throughout, and the first 4 rows of tables sat empty the whole time because no one wanted to sit in front, because that's what we do in school. I feel lucky to be here this morning with my friend Barbara Creel and Professor Pommerscheim to talk about an issue of great import to me. I preside over the Great Falls Division of the Montana District of the United States District Court. Great Falls Division has 4 Indian reservations. I won't quiz you on those, I'm sure you know them. My daughter in 6th grade had her Indian for All Education Act portion of her social studies class this first few months, and she had to learn all 7 reservations and the tribes who inhabit them. So I was happy to assist her with that. I have probably almost 2/3 of my cases come from Indian country under the Major Crimes Act, which provides federal courts with jurisdiction for felony crimes from the reservations. And we're going to talk in particular about a couple of those felony crimes. Most importantly, the felony domestic habitual offender statute, which gives rise to our discussion about the importance of right to counsel for all defendants, including Indian defendants in tribal court. We have strong views about that. And we're also lucky to have Professor Pommerscheim here from the University of South Dakota Law School. I think in districts. The District of South Dakota, where my friend Bob Lang, the judge, I think he has the highest percentage of Indian country cases in the United States. I'm in the top 2 or 3, I think. She's fact-checking me as we go. So anyway, let me start first with Professor Creel. She's going to lay some background for us on the effect of the Indian Civil Rights Act, its application in Indian country, and its intersection with the federal court system. So we'll start with Professor Creel.
You kind of have to eat that mic, sorry. But I'll help you get set up here. I like how I put your thing here and then it's not here anymore. But it's on this, so 1 sec. Okay, yeah, you can start and I'll get your PowerPoint pulled up.
Good morning. It's an honor to be here. It's an honor to be invited with such illustrious scholars and practitioners and students of Indian law. I want to thank the people of Montana, the indigenous people, my ancestors who have gone before me that paved the way to allow me to be here today. I want to thank my parents and my grandparents, my Pueblo brothers and sisters, and all of you today for allowing me to speak on this issue. What I want to talk about today is the Indian Civil Rights Act of 1968 and what it is today. But I want us to think about civil rights for Native American people with the framework and the lens of human rights and fundamental fairness. What I'm asking you to do is to think about the different timelines through Indian law. The timeline of federal Indian law and policy and tribal sovereignty, the timeline of tribal justice through tribal courts, and then the third timeline of the right to counsel under the U.S. Constitution. And with these three different timelines together, think about it with the lens of human rights to determine whether there's equal justice and fairness for Native people in the United States. I come to this issue as a former federal public defender, the only one in the nation who is from a tribal nation. I come from this issue as a tribal woman, a member of the Pueblo of Jemez, and someone who has been directly impacted by the criminal justice system in the United States as it affects Indian people on the reservations. Many of my family members have been caught up in the justice system. One of my cousins died in jail. And we've, in our own reservation, in a remote, one of the most beautiful places in the world, a remote place outside of, about an hour away from Albuquerque in Santa Fe, we've had two really horrific murders that were Major Crimes Act cases. All of this impacts us as tribal people. The United States Supreme Court gets to interpret Indian law and jurisprudence. In the case of U.S. v. Bryant in 2016, the Supreme Court looked at 18 U.S.C. 117 to decide whether a valid tribal court conviction under the Indian Civil Rights Act could be used as a predicate offense in a subsequent federal domestic violence prosecution. What we found was that Ginsburg said, no prior counsel, no problem. And she did so with an eye towards protecting Native American women and children on the Indian reservation. But what was left out by the court was the protection of Indian civil rights and the human rights issues of the right to counsel. I'm wanting to talk about this today, not to talk about the background and history of the Bryant case, but the impact of that case and how it's being wrongly cited for the idea that Indian Civil Rights Act cases that come out of the reservation where convictions are upheld without counsel are fair and valid. That issue was not decided in U.S. v. Bryant. It was conceded. The federal defender conceded that ICRA convictions were valid, and the Supreme Court seized on that. The framework of the right to counsel is really important. So we have to know our U.S. constitutional criminal procedure history first. Understanding this, we have to look at the Supreme Court jurisprudence on the right to counsel. The right to counsel was, in federal court, was decided fairly early on in the early 1900s. Due process and the Sixth Amendment provided that in order to have a fair hearing, you had to have an attorney in a criminal case. The Sixth Amendment provides that you have the right to the assistance of counsel in a criminal defendant's case. You also have the right to call witnesses in your favor and to cross-examine witnesses against you. The federal court saw that as a fundamental fairness issue. In cases like Powell versus Alabama in 1932, and they also evaluated in Avery versus Alabama, finding no due process violations when a person was appointed counsel but didn't have enough time to talk with the counsel before a capital case. Moving forward, after the 1930s came a case called Betts v. Brady. And we don't study Betts v. Brady in criminal procedure because it was overruled by Gideon. But Betts v. Brady is important to Indian country because that's the framework that Indian defendants are working with. In 1942, the Supreme Court reviewed whether the due process clause of the U.S. Constitution provided that all people who were facing criminal convictions were entitled to a court-appointed attorney. and they found that it did not. The 14th Amendment did not extend the Fifth Amendment due process to defendants anytime they faced a criminal proceeding. That issue was reviewed again in the case of Gideon versus Wainwright. In 1963, the Supreme Court decided that it was fundamentally required for fairness and due process to have an attorney in a criminal prosecution. What changed between 1942 and 1963? The Constitution wasn't amended. It was the interpretation by the Supreme Court that in order to have a fair hearing, in order to have all the rights that were provided in the Fifth and Sixth Amendment, the compulsory process, the confrontation rights, the rights to notice, to understand charges, to be free from violations of those rights, to have your Fifth Amendment right to remain silent and not provide evidence against yourself, all of those required an attorney. What was easy for an attorney might be complex and unintelligible for the layman. Gideon was followed up by a case in 1972, Argersinger versus Hamlin, in which the Supreme Court decided that any time, if there was a question about whether Gideon applied to misdemeanors or petty offenses, any time an individual defendant was facing jail time, they were entitled to a court-appointed attorney if they couldn't afford one. You overlay this right to counsel jurisprudence in the Supreme Court with Indian country jurisprudence. The right to counsel didn't emerge until 2010. What happened that allowed Indian country cases to be left behind in this civil rights debate? As we know, and there are many Indian law scholars here that know, and those of us that are studying Indian law, the tribal law and policy, and that tribes are pre-constitutional, outside the U.S. Constitution, because they pre-existed before the formation of the United States. Therefore, the United States Constitution doesn't apply to Indian tribes. They weren't incorporated or considered by the Founding Fathers. The references that Congress review in understanding the plenary power were Indians not taxed. So because of a case in 1879 where the Supreme Court said that tribes are outside of the United States Constitution, Congress took up the issue of Indian civil rights within their own governments in the 1960s civil rights era. And at that time, the right to counsel was still emerging for the states. Due process in the 14th Amendment didn't require Indian defense counsel until 1963. And then it wasn't applied again to the states for misdemeanors in 1972. So when Congress passed the Indian Civil Rights Act to determine whether to sort of cut and paste the Bill of Rights from the Constitution to apply to Indian tribes, they left out the right to counsel. And the ICRA provides for right to counsel at his or her own expense. This sort of mirrored what was the law at the time during Betts v. Brady before Gideon and Argersinger. So Congress was following what the law of the United States land was. Many states had the right to counsel for indigent defendants. Many states did not. Betts v. Brady said, we're not going to require all states to provide indigent defense counsel. And Gideon said the opposite. The right to counsel wasn't just a decision by Congress. It was a legacy that was left over from Indian law and policy. In the 1800s, the Commissioner of Indian Affairs, Teller, created Bureau of Indian Affairs courts, also called courts of federal regulation, or courts of Indian offenses. This set of courts was set on Indian reservations with the attempt to civilize natives by punishing them for speaking their language, for dancing their ceremonial dances, for plural marriages, for not respecting private property, for crimes like theft. The punishments could include losing your rations, being imprisoned, being forced to hard labor, or being fined. The courts of Indian offenses prohibited attorneys. This meant that the Indian defendant would face the Indian agent or judge for these courts of Indian offenses crimes and could be charged, convicted, without any assistance of counsel. The rules at the time provided that attorneys would just get in the way, that they weren't necessary, that the Indian agent had the Indian individual's concern for civilization in his mind, and so it wasn't a legal issue, it was one of more of civilizing the Indian. After the Indian Reorganization Act in 1934, the BIA provided templates for tribes to create their own constitutions and set up their own judiciaries as a sovereign act. These templates provided for a prohibition of the right to counsel as well. Tribes that adopted them adopted this colonial view and the oppressor's view that attorneys weren't necessary. The prohibition against attorneys stayed on the books until 1961, when, during the debate on the Indian Civil Rights Act, Congress asked the Bureau of Indian Affairs why there was a prohibition against counsel for Native Americans in their tribal or CIO courts. They couldn't find an answer. The answer was, well, maybe there weren't any attorneys. Was only a few Indian attorneys anyway, and they're representing other interests. They're busy. And anyway, who would want to come and represent natives in these cases? The second was attorneys for Indians weren't necessary. They would just get in the way. These are simple cases, misdemeanor cases, and they're not complex, and it would really just deter justice. And finally, who would pay for these attorneys? Where do we get the financial resources? Tribes are poor, and certainly the Bureau of Indian Affairs wasn't going to pay for defense counsel for Indians. This was the law and the rights of Indian people to only have attorneys under the Indian Civil Rights Act in their own tribal courts until 2010, after the Tribal Law and Order Act imposed these special requirements if the tribe was going to enhance their sentencing, meaning beyond 1 year that's provided in the Indian Civil Rights Act. From 1 year to 3 years for recidivists or for felony-type cases, and those cases could be stacked from up to 9 years, from 1 to 9 years. Beyond any time a tribe is going to impose a criminal punishment beyond 1 year in any criminal proceeding, Tribal Law and Order Act provided that they must provide a public hearing, publicly available and written laws, a law-trained judge, and the right to counsel at the tribe's expense. TLOA was the basis for providing the minimal process and constitutional type requirements before you could imprison an Indian in tribal court for more than 1 year. And it also provided the foundation for the Violence Against Women Act provisions in 2013, which expanded jurisdiction for tribal courts over non-Indians if they had these special protections in place that were constitutional, U.S. constitutional based. But this wasn't the first time that Indians had the right to counsel. Indians had the right to counsel under the original 1968 Act as a due process right. And we look at ICRA, it provides for those due process requirements that I mentioned before. Notice, the right to compulsory process, the right to confront, and a right to a jury trial. All of those were encompassed in 1968. So the question that I'm offering to the panel and to you is, what has changed in Indian country? Why is it that Native Americans can face incarceration, whether it's 1 day or up to a year, without the assistance or the benefit of counsel? What makes Indians different than the defendant in Gideon or Argersinger, that any time they're facing incarceration, they're entitled to counsel? The problems aren't just the direct impacts of being incarcerated in an unfair, fundamentally unfair trial, but they reverberate throughout the U.S. Jurisprudence, because then they can be used as predicate offenses, as was in 18 U.S.C. 117 in the Bryant case. What Ginsburg decided was that these prior cases were uncounseled or okay because they were valid under ICRA. And I'm presenting to you that they're not valid. They're invalid. They're fundamentally unfair. And all of us should be challenging that, as Native Americans do not have lesser rights in the United States under the Constitution, and tribes shouldn't be denigrating their own sovereignty by having this fundamentally unfair process move forward. There's lots more to talk about, and I'm looking forward to the exchange with the panel and with you. Thank you.
Thank you, Professor Creel. One of the problems that arises when someone is deprived of counsel is they make unwise decisions. And one of the classic unwise decisions a person accused of a crime makes is to speak with law enforcement. So Professor Pommerscheim is going to talk to us about the Miranda decision and its implication with regard to the Indian Civil Rights Act.
Thank you, Judge. It's a delight for me to be on the panel with my colleagues here. It's wonderful to see so many friends from the Indian law scholarly community out there, so I'm delighted to be here. I wanted to start by reading the title of my piece and to talk about the first footnote that appears in my piece, then to read the first sentence that actually is in the piece, and then I'll just fire away in terms of the stuff that I'm actually going to be talking about. The title of my short article is United States versus Gillette, a tiny prairie case note, opening a window on the enveloping fog obscuring the Indian Civil Rights Act of 1968. A typical scholarly title. But there's a footnote, and the footnote is a footnote about form. This tiny prairie case note emulates National Public Radio's tiny desk concert format. You show up in the studio and play some music. People say that's interesting. I haven't heard anything like that before. It makes me want to hear more. That is the goal here. Raise questions, provide few, if any, answers, extend an invitation to further engagement and discussion. The first sentence of my article reads like this. Gillette is one of the first cases on in these new post-Bryant times, on the new post-Bryant road. There is no reliable legal GPS to guide the way. This case note is not meant to criticize the answers provided by Gillette, but rather to clarify the questions as the journey continues. I also want to make several disclosures. This case caught my attention because it came and originates on the Rosebud Sioux Indian Reservation. I lived and worked there for 10 years. I have served and continue to serve on the Rosebud Sioux Supreme Court. And so when I saw a case involving Rosebud, which I had not reached the Rosebud Sioux Supreme Court, I was really interested in it. I know the tribal judge who took the guilty plea. I know the public defender who represented Mr. Gillette. I know Judge Lang, who rendered the federal district court decision. I know his law clerk. I know his spouse, who was my former student, and my research assistant. And I married her and Judge Lang's law clerk. So I just want to get those disclosures out there and might color what I have to say or not have to say. Thirdly, both in the background and permeating any discussion about 18 U.S.C. 117A, domestic assault by a habitual offender, is the goal of that statute to protect and advance protections for Native women. And so that's just a given in the background of my presentation. But I want to address what appear to be like growing issues in the post-Bryant context that I think judges are going to have to confront, practitioners are going to have to confront, and so I want to try to illuminate and get some of those questions out there. But what happened in United States versus Gillette? What happened in United States versus Gillette, that there was a domestic disturbance call on the Rosebud Sioux Indian Reservation. And Officer Reynolds answered that the domestic assault call. He went to the home of Mr. Gillette and the person, his domestic partner. And when he answered that call, it appeared to him that there was domestic assault taking place. And so he started to question Mr. Gillette and did not give him any Miranda warnings whatsoever. He subsequently arrested Mr. Gillette. Mr. Gillette was charged in tribal court with several offenses, including domestic assault. He was represented in counsel before the Rosebud Sioux Tribal Court, and he pled guilty to all the charges, including the tribal code violation of domestic violence. 4 months later, a grand jury indicted him pursuant to 18 U.S.C. 117A. The first thing his defense counsel did in his federal prosecution under 117A was to file a motion to suppress statements that he made to Officer Reynolds because he claimed, his defense counsel claimed, that they violated Miranda versus Arizona. He also filed a motion to suppress the admission of his guilty plea in tribal court, claiming that it violated the Fifth Amendment to the United States Constitution. I'm going to focus on the Miranda part. And it was briefed, it's just in the context of a motion to suppress. It was briefed, not very comprehensively, both by the public defender and by the U.S. Attorney's Office. And Judge Lang ruled in ruling on the motion to suppress in violation of Miranda without too much discussion. Again, this is only in the context of a motion to suppress. It wasn't after a full body trial. It's really not a full district court opinion. It's just a decision based on the motion to suppress. He simply applied Miranda versus Arizona. He made no reference to ICRA. He made no reference to the Rosebud Sioux Tribal Code, the Rosebud Sioux Tribal Constitution. And for me, that seemed kind of problematical in terms of what is the standard that a federal district judge should use in the context of a 118 prosecution when there's a motion to suppress statements made in violation of Miranda. Now, to try to keep this straight, this is not looking back, but it's looking forward to the actual the 18 U.S.C. 117A prosecution. And in this way, it's not like Bryant. It's kind of an offshoot of Bryant, because Bryant was looking back to those tribal court guilty pleas to see if they were valid as predicates for the 117. But in Gillette, it's not about the predicates, it's actually about the offense he was charged in the context of the 117. And Judge Lang simply said in the context of a Miranda claim, he would just apply Miranda versus United States. Now, I'm not saying that's wrong, but to me, and this is what I hope we can generate a conversation about it, well, is that right or wrong? Or should he have applied what I would call ICRA's Miranda? Because ICRA under Miranda is similar but not identical by any means. And, of course, what got my attention, because I am on the Rosebud Sioux Supreme Court, there was no discussion of the Rosebud Sioux Constitution. And so, to me, that's a question that's really significant to think about in the context of these 117 kind of prosecutions. And just using Miranda as an example, and I think many other issues will come up in the aftermath about what standard should a federal district judge be applying in the context of 117A prosecutions. Again, they're not like Bryant, where you're looking back to the predicate offenses. I'll have something to say about that as well. But just the instant offense that is the offense that's being charged under the habitual offender statute. And to me, it's kind of critical to kind of think about those. And as I was doing research for writing the paper, I hit on something that might be much more radical, and I'm much more comfortable talking in that context, is I want to put out there that I believe that ICRA does not contain Miranda at all. that there's no Miranda to be found in ICRA. And how do I make that case? Well, if we go back, Miranda was decided in 1966. The Indian Civil Rights Act was passed in 1968, just 2 years later. There's really nothing that I'm aware of in the legislative history of ICRA that makes any reference to Miranda, one. Two, the actual structure of Miranda doesn't easily fit in the context of the Indian Civil Rights Act, because if you think of Miranda literally applying in the Indian Civil Rights Act, where is the right to counsel component that is part of Miranda? Because obviously Miranda is about the Fifth Amendment, but it uses the Sixth Amendment right to counsel to provide sort of prophylactic kind of protection in that particular context. And the Indian Civil Rights Act doesn't have that element of Miranda. So I think we're off and running and saying, well, was that really the intent of Congress and the Indian Civil Rights Act to include Miranda? And the part that I've just identified is, people have talked about that a good deal, and I think they always reach the conclusion, well, there's some part of Miranda in ICRA. But the thing that hasn't been talked about that I'm aware of is actually when Miranda was decided, it was not clear that it was a constitutional decision. And why wasn't it clear? Well, there are a number of scholars and courts who thought that the decision itself, that is Miranda versus Arizona, wasn't absolutely clear whether it was meant to be a constitutional decision interpreting the Fifth Amendment. A number of people thought that it was actually not a constitutional decision, but just an example of rulemaking by the United States Supreme Court, just saying that the Miranda protections and the right to counsel go along with that was not meant to be constitutional, but just an example of Supreme Court rulemaking in the context of the Supreme Court can set rules for how federal courts handle prosecutions. And so it was kind of up in the air in terms of, well, was Miranda constitutional? Or was it just the Supreme Court's rulemaking? And then finally, that dispute was only answered, if my math is correct, approximately 37 years later in Dickerson versus the United States. So it was finally Dickerson versus the United States in the year 2000 that said, wait a minute, indeed, Miranda is a constitutional decision. But one of the things that happened in the very year that Congress passed the Indian Civil Rights Act, it also passed Section 3501, 18 U.S.C. 3501. And 18 U.S.C. 3501 established sort of the voluntariness standard that Congress passed 3501 to say that the federal standard for accepting guilty pleas was a voluntariness standard, which did not include Miranda in it. And so there was tension between whether Miranda was a constitutional decision, which would surpass 3501's voluntariness standard, or whether 3501 would overcome Miranda if it was only an example of Supreme Court rulemaking in the context of how to take evidence and proceed in a federal proceeding. And in Dickerson versus the United States, the Supreme Court said it's constitutional. But it's interesting because 3501 was passed in 1968, the exact year the Indian Civil Rights Act was passed. And Dickerson actually says that the intent of Congress in 3501 was to overrule Miranda. And if you accept the Supreme Court's characterization of 3501 as having the intent to overrule Miranda, it failed 36 years later in Dickerson. But to me, that's very revealing of Congress's attitude in 1968. It was hostile to Miranda. And if it was hostile to Miranda as exhibited by the court's own opinion in Dickerson, I would venture to say that Congress could have never intended that any part of Miranda be part of the Indian Civil Rights Act. And that's something that I hope there'll be questions and feedback to say, wow, that's an incredible insight, or like, what the fuck's on your mind? Or something in between. But I think that's an important thing to be kind of thinking about. I would also say that Dickerson versus United States can't cure ICRA. You know, it says that Miranda is constitutional, But we all know that when ICRA was passed, it has no constitutional underpinnings. There are no constitutional rights in ICRA, only ICRA rights. And so the fact that Dickerson declared Miranda to be constitutional, I would argue that can't possibly affect ICRA. Congress could turn around, if I'm right in what I'm saying, Congress could turn around and go back to ICRA. It could amend ICRA to explicitly say it does include Miranda. And I think at a minimum, Congress needs to clarify what ICRA is in Indian country. And I think the Dickerson kind of thing is an important thing to be thinking about and to put out there. And so to recap, in the context of 117A prosecutions, I think there needs to be additional discussion by people in the legal community, by people who represent Native people, people who prosecute Native people, the judiciary, about how it is going to see Miranda in the context of 117A prosecutions. And again, not in the context of going back and examining them in the context of predicate offenses, but in the instant offense under which they have been charged and which they're actually being prosecuted for. And I think that's an important thing to keep in mind. I wanted to add one other thing, which is not an issue in Gillette, but the second issue that actually came up in the context of Gillette was a challenge to using Mr. Gillette's guilty plea in tribal court, in federal court, in his prosecution under 117A. And so what standard, again, should the federal district judge use when confronted with a motion to suppress a guilty plea that was offered in tribal court, again, prospectively in the context of the ongoing prosecution in 18 U.S.C. 117A. And what Judge Lang did in that part of his decision was to say that the Fifth Amendment doesn't apply against the tribe. ICRA does apply against the tribe. There's a due process guarantee in ICRA at 13028. It's not identical to the Fifth Amendment's due process, but it's kind of similar. It's in the same ballpark. And then it examined piece by piece the guilty plea that was taken by the tribal judge in that case. And that guilty plea was taken, and to me, my friendship and prejudice to one side, in a very, very effective way. And Judge Lang just went down and said the way this guilty plea was taken in tribal court comports with due process as we would understand it, not in the context of the Fifth Amendment due process, because he believed, I think correctly, it couldn't apply against the tribe, but the due process guarantee in ICRA at 13028. And I think that's an important thing to see, because I think that issue will come up again. And again, Gillette's just a federal district court kind of decision. And so I think the federal judiciary throughout Indian country is likely to be confronted with these issues. I'm not watching the time.
You're okay.
Okay, good.
I'll interrupt. I have no compunction by interrupting.
Well, that's good, because you're a judge. My students, I'm notorious with my students, like going on, and I can hear them rattling their papers, and I say, like, someplace in the world, it's not time for this class to end. You may look at the clock and say this class is over, but someplace around the world this class isn't over, so we'll just stay kind of a bit longer while we discuss issues. The other issue I want to bring up in the context of 18 U.S.C. 117A prosecutions is going to be, can there be or can't there be collateral attack on the predicate crimes that have been committed? And I'll use Miranda as an example, which is not an issue in the context of Gillette. What about the fact where in both, this is a hypothetical, in the context of an 18 U.S.C. 117 prosecution, the two predicate offenses were offenses that were pled guilty to in tribal court, and the defendant wants to challenge those predicate offenses as violating Miranda, and assume it's true that there were no Miranda warnings given when he pled guilty or was found guilty in those predicate offenses. Now, in the context of an ongoing 117A prosecution, can he or she, well, be he, can he collaterally attack those predicate decisions saying that they violated his Miranda rights, either straight up Miranda or even Miranda under ICRA or even tribal Miranda? And I think one of the looming things, I don't think answered by Bryant, will be this issue of collateral attack. Will defendants have the opportunity in the 117A prosecution to loop back to those predicate offenses and collaterally attack them as being violative of the United States Constitution or violative of ICRA or violative of some tribal constitutional guarantee? And this is the conversation I wanted to put out there. I also wanted to say this sort of in the disclosure kind of context. In reading the Gillette decision when they're talking about Rosebud and Miranda, I'm saying to myself, God damn it, there's a case decided by the Rosebud Sioux Supreme Court called Luxon versus the Rosebud Sioux Tribe, decided by the Rosebud Supreme Court. Full disclosure, I wrote that decision for the Rosebud Sioux Supreme Court, and we said that Miranda is in the tribal constitution textually. And so the Rosebud Sioux Supreme Court decided that Miranda is part of Rosebud Sioux Tribe's constitutional law because there's language to that effect right in the tribe's constitution, one of its recent amendments. And I was trying to keep my language clean. My students generally wouldn't believe that, but that was sort of problematic to me to read Gillette, and there's not a single reference to Rosebud Sioux Tribe versus Luxon. And so, to me, an important element in thinking about 117A prosecutions is what role does tribal law, tribal constitutional law, tribal decisional law play in any of this? I'm not saying I know what the answer is, but I think at a minimum, judges should be thinking about that, even if they ultimately decide it's not appropriate, because I think it's necessary for the federal judiciary, even when they decide correctly and straightforwardly that maybe tribal law doesn't apply, or tribal decision doesn't apply, or tribal constitution element doesn't apply, but at least to acknowledge that it's real, that it's there, because I think when you don't even engage it, the implication is that it doesn't exist. And I think that's sort of problematical for a federal judiciary, however inadvertently, because the federal judiciary at the district court level in South Dakota is very strong, very, very capable, very fair-minded, very thoughtful in their Indian law decision. I'm not intimating anything to the contrary, but it's just more as a general proposition, and the notion that I think it's important to engage tribal law. To pretend it's not there, however inadvertent, I think that sends sort of a negative message. It's like you're not there kind of message. It doesn't show kind of respect, and I think respect is sort of a cardinal thing that needs to be engaged by the federal judiciary, even when they decide, correctly perhaps, that a federal law, the tribe's constitution, tribe's constitutional decision doesn't really apply. That could very well be the case. So I think it's important to make sure that the federal district court engages that. So to summarize, for me, in the context of a 117, just talking about Miranda, federal district courts have to engage which Miranda applies in a challenge to the ongoing prosecution, which Miranda applies, one. Two, sort of a different issue, which is not the issue in Gillette, which will come up later, is can you collaterally attack those past guilty pleas or when you've been found guilty pursuant to a trial? How much collateral attack is actually available? And I think it's just important to be thinking about those issues, to engage those issues, and then more broadly, whether it might be true or is at least worthy of more discussion that perhaps ICRA doesn't have any Miranda content. And does that lead us to think that maybe ICRA does need to be in some way revisited or not? Or is ICRA kind of clear enough that it doesn't provide any problems, handicaps, gray areas in 117A prosecutions?
Frank, I will interrupt now.
I was just going to say thank you.
I will speak up on behalf of the Montana Federal Judiciary. Let's focus first on your question about collateral attacks. When I was having the hearing in the Kirkcaldy case, that was the Bryant-type issue order that I had, and I thought it was a better vehicle for the court to consider, because in Kirkcaldy, the defendant not only had 2 uncounseled convictions in the tribal court for which he faced jail time, but he actually served jail time on those convictions. So the U.S. attorney was arguing the case, and we got into this issue, started getting into this area about collateral attacks. And she starts going on about the Custis decision, and that perked me up, because I thought, well, I remember that haggard, young, overwhelmed law clerk from Montana who was involved in a lot of the drafting of the Custis decision for Chief Justice Rehnquist. I said, gee, I think I can tell you about Custis, what the court was thinking with regard to collateral attacks. So it brought to mind, when I was on the Montana Supreme Court, we had a similar issue with felony DUIs. If you have a 4th offense DUI as a felony under Montana law, and the court faced the question, what do you do about tribal DUI convictions? And my colleague, former colleague, Jim Nelson, wrote an opinion. He said, well, we have to accept the validity of that tribal court conviction. Otherwise, we'd be impugning the integrity of the tribal court and disrespecting its sovereignty. And that always struck me as somewhat odd. I mean, we had similar issues with like the state of South Dakota. We have reviewed prior convictions from South Dakota. And South Dakota has a strange law called we call it the Sturgis Law. This is when Frank and all the middle-aged motorcyclists put their Harleys on a trailer, drive to the edge of Sturgis,
I take that as a compliment, call me middle-aged.
roll through town on their motorcycles and raise hell. They want to keep a lid on all that activity, but they don't want to discourage the couple 100,000 people who roll into Sturgis and drop off millions of dollars every year. So they have sort of a get-out-of-jail-free DUI. You plead guilty, you're on your way. So we examined very carefully the elements of that South Dakota DUI conviction and decided it didn't qualify as a predicate offense under Montana law. We had no concern about respecting the sovereignty of the South Dakota legislature like that. We said, we'll look at those very carefully. Why shouldn't federal courts look at the validity of tribal court convictions under Custis when we're looking at predicate offenses?
Well, I guess my response is, I mean, Custis, the way I read Custis, and I'm not an expert, I mean, stands for like a different proposition. I mean, it says you can only collaterally attack.
Well, where you were uncounseled.
Right.
Right, but there's a lot of, you hear a lot of people, well, you can't look at these tribal court convictions, otherwise you're disrespecting the tribal court and you're attacking their sovereignty. Is that something that federal court should be concerned about? Because we're not, I mean, the way I look at it, I'm not challenging the validity of a conviction for purposes of tribal court. I'm deciding whether that information should be admitted in a federal court proceeding.
No, I mean, I agree with that. To me, that's the issue to be talking about, is like whether Custis should apply in the 117 context, or is it doesn't apply? Because if you follow Custis, to me, and maybe I'm wrong, it's a bit circular, because Custis stands for the proposition you can only collateral attack state convictions in federal court if you didn't have the right to counsel, and you can show affirmative also that you didn't waive your right to counsel. Well, if you just try to apply that in the tribal court context, in the Bryant context, to me it gets a bit circular, because it's very likely that those tribal court predicate offenses, the person wasn't represented. And so that might just open the door that you could, even pursuant to kind of Custis.
Well, that's what I would think.
Yeah.
But the argument was, no, we shouldn't even look at that. They have to accept them on their face.
Well, that's what Bryant said, and I guess for me, that's the question that, you know, I want people to engage about, whether you should be able to collaterally attack those predicate decisions in tribal court, and in the context of, is that disrespectful to tribal courts and to tribal sovereignty? To me, that's an issue for discussion, but it's also, to me, you'd have to talk about how Custis kind of applies or doesn't apply. I think you could distinguish it and say it doesn't apply or ought not to apply in the context of a 117A.
There's more to it, though. I mean, I don't think you can conflate respect for tribal sovereignty. I don't think you can conflate honoring a prior conviction as valid under the U.S. Constitution with respecting tribal sovereignty. And this is the notion that I want to get at, is that as Indian law scholars, we have been studying tribal sovereignty, and we want to protect, as tribal practitioners, we want to protect tribal sovereignty. Challenging a tribal decision, a sovereign decision, of a nation under a separate court doesn't do anything to touch the sovereignty of the underlying court. So a tribal decision, a tribal sovereign decision not to have counsel is still upheld, but looking at that decision in another court and whether it comports with US principles is what the United States Supreme Court missed. The Ninth Circuit in Ant says you look through the tribal court decision to decide whether it can be upheld in our fundamental fairness. And what I'm trying to explain to you today is because of this progeny of the right to counsel, the Sixth Amendment jurisprudence, uncounseled convictions cannot withstand any scrutiny. It's fundamentally unfair to have them, and especially unfair to then repeat that unfairness and allow them to be upheld again. But there's another issue. It's not just respect and the confusion about tribal sovereignty. It's also racial equity and social justice in the United States. That Native Americans are the only people that can be incarcerated without an attorney, and then those convictions can be used against them in federal court for longer sentences. That's the timeline that I introduced you to in the beginning. It's the same as the CIO courts, where they want to civilize the Indian. Ginsburg talks about the need to get at domestic violence on the reservation, and 117 is the way to do that. By allowing these uncounseled convictions, it's expediency. It's allowing us to punish the Indian more without the intrusion of a defense counsel.
Well, Barbara, that was one of the more frustrating parts of the Bryant decision to me was, well, we have this epidemic of violence against women in Indian country, and I certainly see that every day in my court, and I agree with it wholeheartedly. But we have other problems in our country. We have epidemics of violence. We've heard about the homicide rates in the city of Chicago. We had problems in Baltimore. I don't hear anyone saying, well, let's suspend the Fourth Amendment in Chicago so we can go around, round up all those guns and make the streets safer. Or let's dispense with some other aspect of due process in order to get to the heart of this problem. We can really clean up these streets. Why is it okay to shortcut due process rights on Indian country, but not everywhere else in the country?
That's the question that I have, and I heard a lot about it last night at the Montana Justice Initiative talk about Native narratives and the way that Natives are viewed throughout history that allows their punishment to be greater and have less rights. After the O.J. Simpson case, California passed an evidence law that said hearsay statements of the decedent could be brought in a domestic violence case where there were prior threats of violence. And the Supreme Court struck that down and said that domestic violence is a terrible thing, and the states have many options at their hands. They can pass tougher sentencing, they can provide treatment, but what they can't do is short-circuit a defendant's rights and allow these statements to come in just to get a prosecution. And that kind of analysis is what we need in Indian country. It's the short-circuiting of a Native American's rights, not just as an indigenous person, but also a U.S. citizen, which shouldn't make a difference, right? But also in racial justice, that looking at domestic violence on the Indian reservation, there's a Department of Justice report that says non-Indian perpetrators Native women are subject to violence by the hands of non-Indian perpetrators at greater rates. What 117 does is try to get at Native-on-Native crime and attack domestic violence. But the purpose of ICRA from its very beginning was to make sure that Indians had civil rights. So there weren't any civil rights gaps because of the pre-constitutional nature of tribes. And so what we've done by this complication of, oh, does the U.S. Constitution apply? Does it not apply? Are they citizens? Are they not citizens? Are they entitled to equal protection or not? We've confused it in a way and allowed that fog of racial justice to cloud the view of natives. And then respect for tribal sovereignty is the sort of the shield against that. As long as tribal sovereignty is respected, you can do whatever you want to the Indian individual.
Let's go further down the path of how the different treatment with regard to counsel plays out when you have the intersection of the tribal prosecutions with federal prosecutions. I had a suppression hearing a couple months ago, and the defendant was in tribal custody. And so the FBI wanted to speak to him. So there's no doubt that if a person was charged in federal court and was appointed counsel in federal court, and the FBI wished to speak with that incarcerated defendant, they first would have to contact his counsel. And there's no doubt that if Glacier County or Roosevelt County charged that same person with the same crime, and he were appointed counsel, and the FBI wished to speak to that incarcerated person, they would have to go through his counsel. So this case started out, the FBI this was up on Fort Peck Reservation, and the person was held in the tribal detention center. And the FBI showed up the first time to speak to him, and he was charged in tribal court and not yet have counsel. So he comes out for the meeting with the FBI agent and the tribal law enforcement officer, and they tell him, we're here to talk to you, and he says, I want to get this taken care of, I want a lawyer, I want to get to court right now and get this taken care of. And so the FBI explains, well, you know, you don't have a right to a lawyer yet, you haven't been charged anything in federal court. Until you're charged in federal court, you don't have a right to counsel, so that's where we are, and brushed it past it. Interviewed the defendant, he didn't say much incriminating. So they came back later, a second time. At that point, the person had been charged in tribal court and had a tribal advocate. And on the Fort Peck Reservation, they have tribal advocates, they're non-trained advocates. So same FBI agent, same tribal officer comes out and for the same interview with the defendant. And the first thing the defendant says is, oh, what about, what's his name? My guy, shouldn't he be here? And the FBI agent, well, again, the same process, you're not entitled to a lawyer. He was referring to his tribal advocate. He says, you're not entitled to a lawyer until you're charged in federal court. So you're not charged in federal court, even though you're charged in tribal court and you're in custody, and proceeded to talk to him, in which he made incriminating statements. So how do you reconcile that differing treatment with how we should look at that in federal court?
Well, I would say that treatment's wrong. I think once a person is represented, that's it for the defense.
But I mean, technically, the FBI's right, aren't they? I mean, he doesn't have a counsel appointed. He doesn't have a right to his, in federal court, this tribal advocate's not a lawyer, so why do they have to go through the tribal advocate? Well, I was able to avoid that question by suppressing the statement on the grounds that under the clear statement rule, as soon as he was first asked about the interview, the first thing out of his mouth was, I want to get a lawyer and get this settled. So the FBI had a duty to clarify what he meant by that. But you take that away, and I'm not sure that the FBI technically acted improperly under federal law by not going through the tribal advocate. What is your view on this?
Well, my view would be that it would be wrong that once any defendant is represented by counsel, when the feds...
But it's not a counsel, it's an advocate.
Well, just let me finish, right? The law is all about words. So you could say, according to tribal law, he is a counsel. Because most tribal courts where they recognize what are called lay advocates or tribal advocates, they have the same rights and responsibilities in representing their clients. So you could make that...
Well, then why wouldn't that same person be sufficient for purposes of predicate offenses under Bryant if they had a tribal, non-law trained tribal advocate in tribal court?
Well, then they'd be represented by counsel. I don't see that as a Bryant issue. Because the Bryant issue is about uncounseled decisions.
So tribes have the authority to decide what constitutes counsel.
And
I think for purposes of their court system, yes.
Right, for the purpose of their court system, I agree, but does the federal court have to defer to that determination?
Well, they have to engage it, and I'd be interested in hearing why they wouldn't respect it.
And this is the question that came up in the minds of Congress in passing the Violence Against Women Act of 2013, is what laws apply, and does the U.S. constitutional principles and standards apply? And they answered that for non-Indians being subject to tribal court jurisdiction in the affirmative, saying you have to have U.S. constitutional rights anytime that you are a non-Indian in front of an Indian tribal court. So Congress foresaw this this gap between the Indian Civil Rights Act and U.S. constitutional principles. So why did they answer it for non-Indians or white people being faced with a crime, but not Indians? That just does not make sense logically. It doesn't make sense in fundamental fairness or due process, that an Indian, because of his complexion or because of his tribal enrollment, would have different rights vis-a-vis the U.S. Constitution. And whatever the rights are in the tribal court, why would they be recognized separately just because he's Indian?
Would you explain, again, this is a political classification, not a racial classification, and how that's justified under federal law?
Oh, it's racial. It's racial from the very beginning. But in Morton v. Mancari, the question was whether Native Americans could have hiring preference in the Bureau of Indian Affairs because they were the people most affected by the rules and regulations and federal policies of the Bureau of Indian Affairs. And the answer in an employment law context was Native American preference was allowable, because tribal people have a political status with a separate relationship with the nation-to-nation government under the U.S. Trust responsibility. And so tribal people, as Indian individuals, have a political status that's different. That case, Morton v. Mancari, has been used to uphold the idea that people from a tribal nation, tribal citizens, aren't a racial classification, but a political status. And so therefore, things like double jeopardy or punishing natives differently under the U.S. system can be upheld. But ultimately, it's about race.
And that's not such. If it's not about race, if it's about political classification, it's not always that easy to determine. You know, one of the elements of most of these crimes in the Major Crimes Act is that the perpetrator or the victim is an Indian person. And the test for Indian personness is pretty vague.
Spaced.
You know, I had a trial once. It was an assault. The defendant was from California, not an Indian person, and everyone saw, their witnesses saw the assault, and there was no doubt it happened. But the really one issue to be resolved by the jury was the defendant an Indian person? And he was 1/16 native blood. And so we had to put on evidence of all the other indicators of tribal status. Well, so people have the impression that everyone knows who's an Indian person, who's not. It's not that clear cut. So you want to talk briefly about who's swept up into this justice system?
Yeah, I'll just go back for a minute, because to talk about the right to counsel, to me, this discussion is kind of helpful, because to me, all these problems in the context of the right to counsel proceed from a fundamental misunderstanding of the right to counsel in ICRA. Because I would put it forward this way, just thinking about it now, is that the right to counsel under ICRA was meant to be the constitutional standard, because that was the constitutional standard in 1968. And so if you hew to that line, that ICRA actually established a constitutional right to counsel, because that was the constitutional standard in 1968, we wouldn't have any of these issues that we're talking about. And so to me, it's worth discussing about going back to whether the ICRA right to counsel, which was the constitutional standard in '68, and now it's kind of slipped away after Argersinger and stuff, is that a fundamental mistake that we, whoever the collective we is, to go back to Congress to clarify or get judicial decisions? I think Barbara has suggested this, that, you know, I think a federal district judge could say in the context of the right to counsel that the right to counsel under ICRA is the constitutional standard. And the constitutional standard has evolved, but that was the intent of Congress, to have a constitutional standard. It's evolved. Judges ought to apply that evolving notion of what the constitutional standard is, because you can argue, I think, compellingly, that that was Congress's intent in 1968, and I think that's important. As to the issue about who is an Indian, well, I always tell my students it's amazing that the Major Crimes Act was passed in 1885, and here we are, here 2018, the Supreme Court has never answered that question about what the term word Indian means in the Major Crimes Act.
You're an Eighth Circuit person. You don't have to deal with an Ninth Circuit test.
Well, yeah, we have our own test in the Eighth Circuit, but I mean, you know, that issue about who is an Indian, you know, has kind of permeated Indian law almost from the very beginning, and I think we have never achieved a coherent definition of what it is to be Indian. Is it racial? Is it political? Well, to me, it's not either or. And I tell my students, well, yeah, it's political if you use Morton versus Mancari, but if a Native person claims that he got fired from her job because she's Indian, does she have to be a member of a federally recognized tribe to bring a discrimination action? I think the answer is no. She just has to establish some way that she is racially Indian. She doesn't have to prove, that I'm aware of, that she's a member of a federally recognized tribe. So I think the whole issue about who is an Indian for what purpose has kind of beleaguered Indian law from the very beginning, and the Major Crimes Act is a good example. I always tell my students, one of these days, for better or for worse, the Supreme Court will have to confront that issue about what that one word means in the Major Crimes Act. What does the word Indian mean? It's not defined in the Major Crimes Act. The Supreme Court has never said what it means. And so, to me, at some point, the Supreme Court will have to answer that issue. And as you indicated, Judge, in the meantime, each circuit has its own kind of definition of the variables that you have to kind of put together.
So I want to address two other topics before we take questions. Barbara, could you talk about what are the practical consequences of being tried in federal court under the Major Crimes Act versus being charged in tribal court or state court? I always tell people, look, if there's an assault in Browning on the Blackfeet Reservation involving 2 Indian people, the consequences are dramatically different if that same assault involving the same 2 people takes place 30 miles away in Cut Bank outside the reservation. They're tried in state court. So when you talk about the effects of the sentencing in federal court versus the state court or tribal court sentences and a decision to remove a case from tribal court to federal court.
Yes, the sentences for Native Americans facing crimes in federal court are much greater. Native Americans are over-incarcerated. They get longer sentences. The study that we did with the U.S. Sentencing Commission found that Natives are less likely to get a downward departure. Under the U.S. sentencing guidelines, that is the way that the prosecution and defense can come to a decision about where in the guidelines the Native person's sentence will be. Natives get a longer sentence. Even when they're within the guideline range, they're usually at the high end. The sentencing guidelines are just guidelines. They allow the courts to take into consideration the other factors under 3553, but for the most part, judges adhere to them. So they face greater consequences unless you, in a state where you have mandatory minimums that are pretty cut and dried. In New Mexico, for a DUI case, the judge has great discretion, and we've seen a doctor kill a young person in a DUI case in Santa Fe and get probation. On the Indian reservation, if you have a DUI death, it can be prosecuted as a vehicular homicide. And then natives are subject to federal law within, for the DUI prosecution. They get longer sentences. You don't have parole, so you don't get that sentence reviewed at any point in time. And so the ultimate effect is more natives are prosecuted in federal court, and they get longer sentences.
No, my friend Judge Ortley is here, former state district court judge in Montana, and I tell people, look, those state sentences you hear, they can sound onerous, but there's always that possibility of parole. You know, in federal court sentence, you do the time. There's no parole involved. You know, you get some good time credits, but that's months, you know, a month or two off per year. So the consequence of having your case transferred from tribal court to a felony in federal court is dramatic. Finally, before we take questions, I get both of you to discuss this issue about, you know, there's a little split, I think, in the scholarly community regarding Indian law about what the best path is. You know, should we be wrangling around here with, well, does ICRA apply? How should federal courts do this? Or there's another voice saying, well, look, tribes are sovereign, tribal courts should be sovereign, they can do what they want, and if it takes sacrificing a generation of Indian defendants through this disparate treatment in federal court, we'll live with that as long as the long-term goal will be we have fully funded tribal courts run by the tribes and they take care of their own affairs. Is that a pipe dream, or is that a realistic goal that's going to have some short-term consequences but long-term benefits? And we repeal the Major Crimes Act and the tribes handle the work.
Well, to me, there has to be, I think, more discussion of all these issues in terms of what actually should be the future in the context that we're just talking about, in the context of criminal law. To me, like, an interesting notion would be, and both of you would know more than I do, to me it'd be interesting if there have been studies about the perceptions of Indian defendants, both in tribal court and in federal court, about how they see their treatment. What would studies show, both in terms of the human terms, of how Indian defendants in tribal courts, their own tribal courts, how do they perceive their treatment? Do they think, even when they don't have access to counsel, that there's something unique about tribal courts? They still feel that they are treated fairly and they don't have an issue with being unrepresented in tribal court? Or, if we did the studies and talked to Indian defendants, would they tell us the exact opposite? Would they tell us, no, we get screwed in our own tribal courts? And so, to me, I'd be interested in kind of knowing how the people who are affected by this, Indian defendants, how do they perceive their treatment in tribal court and in federal court as well? And to me, you know, one of the tentative footnotes in my paper is, you know, we should be careful about speaking about Indian defendants without anyone ever actually speaking to Indian defendants to see how they perceive their treatment. I mean, because, you know, you can drift into this, like, whatever, it's all about tribal sovereignty. I mean, tribal sovereignty is great as a goddamn abstraction, but you have to kind of translate it, how it actually works on the ground, and how it affects people that it is exercising authority over. And in the context we've been talking about, how does that look in the context of tribes exercising their sovereign authority over Indian defendants? And unless I've just missed the literature, which is possible, is I'm interested in knowing how Indian defendants perceive their treatment, you know, both legally, culturally, personally, in tribal court. Because I think that's an important voice that I myself haven't heard. And to me, that's an important voice that we need in this kind of conversation. Because if not, whatever side we're on, if there are sides, I'm a little leery of sides. I think there's kind of a range of things. It's just like, you know, you're saying stuff about people who you haven't bothered to speak to.
I think you have to pick a side. The adversary system is the problem. Superimposing a foreign system called the adversary system onto tribal nations, and then giving them a set of Bill of Rights, and then telling them no counsel is allowed, is unfair. So tribes, as a sovereign act, can make the decision to do better than the adversary system. And in their justice systems, they can create new and different dispute resolution systems. And as long as you're not incarcerating anyone, you're not impacting those core due process rights that we uphold as U.S. citizens. So I think that tribes need to think about their tribal sovereignty. In the Bryant decision, Thomas, in his concurrence upholding the validity of an uncounseled conviction, says that at the core of a tribe's sovereignty is their right to prosecute. And so what we thinking about whether it's fair or not to have the adversary system without any attorneys is the solution for me. There have been other experiments. Public Law 280 was literally an experiment in termination. Let's just see if we can make the Indians go away and let them be under the state jurisdiction. That's a failure. I think the Major Crimes Act has been an experiment. Let's take major crimes, because tribes don't have justice, or at least they didn't in the Kodog case, and move them to federal court where they can be subject to the death penalty at the time in the 1880s, and to more longer, better sentences. That's an experiment. But tribal people and the United States federal courts need to think about the adversary system and what is fundamentally fair for due process.
And one other thing, we've talked a lot about the rights of defendants here, but we haven't talked about victims. This system does not serve victims well, in my view. We think about the practical decision. There are no FBI agents in Montana who live on these reservations. Right. We have an office in Conrad who serves the Blackfeet Reservation as well as the Rocky Boys, and we have an office in Glasgow. They serve the Fort Peck and Fort Belknap. FBI agents, along with other federal employees in some parts of Montana, they receive basically combat pay for serving in Montana. They get a preference on their next assignment if they go to a place like Montana and serve. So we have a rotating FBI office where they 3 years and they're up and out. By the time 3 years, they finally found their way from Conrad to Browning without getting lost. They haven't developed a lot of connections in the community. They're not part of that community. There's distrust in the community toward them. Frankly, a lot of the cases, there'll be an assault on a Saturday night in July, and the person might be arrested in tribal court, and then because they don't have the resources, they're bonded out or released, and they get indicted finally if the FBI gets up there and investigates and gets through, and they get indicted months later. Well, that whole time, the victim is encountering the perpetrator around the community and getting pressure to keep his or her mouth shut. And so by the time we get to trial, you find the witnesses aren't always terribly well prepared. I get these witness statements and read them. Oh, that sounds bad. And the person testifies. I always wonder if it's the same person. And as a result of that, the acquittal rates in my court for cases in Indian country are over 25%. And that's pretty shocking. And I'm sure, Judge Earle, you didn't have that kind of rate in your court. I mean, it doesn't serve the victims of these crimes very well either. So we're going to squeeze in a few questions here from the audience. Sorry about our long-windedness. Ms. Jackson.
Hello.
Oh, you have to hold it
Like this.
Right here.
Okay. I am a karaoke singer. You think I can handle this? So I'm has-been a USA and tribal liaison, and I practice largely in front of Judge Morris. He still scares me. I was at a going-away party for Denise Juneau, and I saw him and I hid. So, because you want to keep that distance. I'm like, wait, I don't practice in front of you. But anyway, I have a question, I think, for Professor Creel. And I'm a little confused about your position, because your position is Bryant Court got it wrong, and that we need attorneys in tribal court to represent defendants, which makes tribal courts look and feel more Anglo. And then on the other hand, you are saying that we need more holistic, more, I guess, non-adversarial proceedings. And I can't justify that in my mind. By the way, 117 was my favorite crime to charge because it was the most effective way I thought we were getting at domestic violence in Indian country was that. And the other premise of yours is that these tribal court decisions without an attorney aren't reliable. And I think that that's an affront to tribal sovereignty right there. So can you justify the two positions that you laid out here about wanting to honor tribal courts as being, you know, these potentially holistic, different view of how to get at justice with your position that we needed to have an attorney as a defendant, right, as an attorney for a defendant?
Absolutely. I don't think attorneys are the answer. In fact, sometimes they're the problem. But when you're having the adversary system, to have no defense attorney, have a prosecutor, a judge, and no defense attorney, that's the adversary system. When tribes were given that system, that wasn't their system. So if tribes are adopting that because they have constitution or because they want to look more like state and federal courts, the only way to do that is to have a defense attorney. Tribes should and could look to alternative systems. And the answer to that is non-incarceration. Treatment for perpetrators, treatment for drug and alcohol abuse, the kinds of treatments that Dr. Corcoran was talking about last night, that get at identity and the issues. So those two ideas aren't in conflict at all. What you would never have in your court would be you against just the other guy, as we had in Gideon or Betts. That's what fairness requires in the U.S. Constitution, and that's all I'm asking for. When you're reviewing those courts in a federal court before someone like Judge Morris, is that fair? No, it's not fair. It's fundamentally unfair.
Well, you're suggesting there's no tribal advocates in those systems.
Yeah, and they've adopted that adversary system without that piece of fundamental fairness. It's not an affront to tribal sovereignty. The tribes had made a sovereign decision to what their courts are going to use. The U.S. courts should look at that and decide whether it comports with our U.S. constitutional principles. Those are two different systems. And so unfortunately, we've collapsed them together and said, oh, tribes can do whatever you want, but don't have attorneys. And we should uphold that as a sovereign decision. And it's a myth. It's a myth that was perpetrated from the very beginning.
Hi there. Thank you both very much. It's really interesting. So my question, I think, is for both of you, but maybe a little bit more for Mr. Creel. But so I think what my concern is with what you're saying is that I think I agree with you on a lot of it. The imperfect imposition of an Anglo-American adversarial system without the corresponding protections. That's a fundamental problem. I disagree that it should be, and you didn't really get exactly how you would cure the problem. I disagree with the idea, with two things, I guess. I disagree with the idea that corrections should come through judicial fiat. I don't think it should. And I disagree with the fact that you could really parse out that the federal courts should have one set of standards and tribal courts another. My sense is that if you feel it's an injustice, if you feel that an injustice was done to Bryant, then I think the underlying convictions very likely would feel unjust to the same person. And so I guess my question is, what I would like to see, and it's frustrating me that tribes haven't done, is why aren't we advocating for amendments to the Indian Civil Rights Act, because it's our own people who are going to jail without lawyers, and our own family members. So why aren't tribes advocating for that change? And to the extent that tribes can't pay for those protections, why aren't tribes pushing the federal government to amend the Civil Rights Act to require that the federal government pay for counsel for indigent defendants who face incarceration? So to me, I just feel like there is a self-determination and a sovereignty piece of this, where you and I would probably end up in very similar places. But I'm just wondering how you feel about what's the mechanism to get there, in a way that both promotes tribal self-determination and also protects Indian defendants.
Yeah, you're absolutely right that there isn't a constituency for Indian defendants. There isn't a lobbyist. And I'm not that person. I'm not saying, yay, more crime on Indian reservations. That's absolutely wrong. And that's the wrong way to think about it, right? I'm talking about the people in my family that will go to jail without an attorney and stay there a really long time. Not only that, but then get repeated sentences on top of each other. And without an attorney, you can't file a writ of habeas corpus. It's too complicated. And so I've seen tribal people go into jail for 5, 6, 7 years without an attorney. That's unfair. So your question is, what's the answer? There is no lobbyist for that, because we've been taught, tribal people, that sovereignty comes from the Department of Justice side, that money flows there for jails, for Indian police, for prosecutors, and for domestic violence treatment. There isn't anything else until 2010 even talked about with regard to alternative justice systems or treatments. And there wasn't any money flowing to tribes for public defenders, because tribes were told no attorneys allowed. They didn't even think about asking for that money. And because now they're being told from the Department of Justice that really it's about building more jails or contracting. Where I come from, the tribe can just sign an order and send a person to jail. There's nothing to process whether what they got in tribal court was fair or not. You have to file a writ of habeas corpus. And so that can't be a challenge to tribal sovereignty, right? That is the remedy. Was this fair or not? So we don't have enough tribal people that have understood and have studied criminal law. We don't have enough tribal people that understand criminal defense. And we don't have enough people that understand this complex interposition between civil rights and criminal law that can also defend Indian individual rights. And I blame that on just sort of the truncation of ICRA after 1978. That there were some really good cases between 68 and 78, but after that, very few, because without an attorney, you can't bring one. And so we have to educate ourselves, and we have to have parity, both on the prosecution and the defense, in order to, and that requires money from Congress.
I'm going to let Judge Monzo ask a question or that off of others.
Well, actually, this isn't a question, but it's a comment related to the statement that Barbara, you made with regard to the disparity in sentencing. And I just wanted to add the caveat, as you know, when we were on the Tribal Issues Advisory Group for the U.S. Sentencing Commission, and Judge Marsh was also on that, it started with the premise that that was indeed the fact that federal sentences were more severe than other sentences that Indian people faced, with exceptions of Arizona, which I had always advocated for, because Indian defendants that go through the state system in Arizona face far greater sentences for what would be characterized as major crimes act.
True.
And so I just wanted to add that caveat.
And that's true in Oregon too, under Measure 11, the really, really long sentences for juveniles and adults.
Last question, I think we're running out of time.
I practiced in Mexico for several decades, and we point out the shortcomings of the adversary system where people don't have a defense lawyer. To me, that's a hallmark not of the adversary system, but more of an inquisitorial system. Back in the 80s, at one point, the Attorney General of Mexico was seen to be overreaching his authority. I found a wonderful passage from a court, perhaps not recognized enough, the West Virginia Supreme Court, the justice wrote a sentence that I just loved, which was, he said, that unlike a common in British colonial North America, the Attorney General of West Virginia has no implied powers. His powers are limited to what's expressed in the statute. So in New Mexico, which adopted common law, is not part of its background, with the American Southwest, and we settled on Spanish, East Coast, people from Europe, and Louisiana has also a civil law background in which the accused is removed children. And without a defense counsel, there's no due process. And I think the adversary system, and there are wonderful quotes from numerous U.S. Supreme Court justices, that it affords people fair opportunity, and central to that fair opportunity is the right to cross-examination. Now, some of my ancestors are from countries that have nothing to do with British colonial America, so it formed the left and right ventricles of my heart, which I assume came from Ireland and Spain, since my mother was born in Montana. Her ancestors were from other countries. So anyone of partial Irish ancestry loves to be not included in English, and on a regular basis. But even so, I recognize the essential nature of cross-examination and a genuine adversary system. And that's where the rights we have, unless they can be enforced, they're hollow rights, there's no substance. So I'll leave it at that. And if you can find a question in there, feel free to.
Well said. I'll say that. Well said. Thank you.
I think are we out of time? Oh, one more question. All right, go ahead.
I'll try to make this a quick one. Judge Morris, when you asked about determining who is an Indian for purposes of the Basic Crimes Act, I always find it interesting that that the defendant has to, or the victim or the defendant has to be an Indian, has to be proven as an element of defense beyond a reasonable doubt before a jury that, is my understanding, almost never consists of Indian people whatsoever. So my question, I usually ask AUSAs this question, but Judge Morris, have you had a jury trial with an Indian defendant where there were Indian jurors?
When I take a guilty plea, I go through the rights the person would be waiving. One of them is the right to trial by jury, and I explain that if you were to request a jury trial, the jury would be comprised of 12 people randomly selected from the jury pool of licensed drivers and registered voters who live in the Great Falls Division of this court. And I always pause and want to add, none of whom will look like you. The population in Montana of Indian persons is about 7%. The Great Falls Division has about 280,000 people in it, 4 reservations. We're not drawing a jury from Browning, or a jury from Box Elder, or a jury from Harlem or Poplar. We're drawing a jury of about 280,000. So it's a small percentage. When Native American or Indian persons get called for jury duty, oftentimes they're from that reservation. It's a small community. They knew about the crime. They're related to someone. They'll be removed. I have had several, not a lot. It's not uncommon to have 1 or 2 at most Indian persons on the jury. To the credit of the U.S. Attorney's Office, I've never had one Batson challenge in my 5 years as a federal judge. So this is just the way the system is. There's no one from Great Falls gets tried by a jury from Glendive. No one from Montana gets tried by a jury in California. This is a unique situation. Another where you're imposing this system and it's treating people a little differently than you would everyone else. So their jury, their peers, comes from north central Montana, well beyond their local community.
We actually have until 10:30.
Oh, we do. There's some hands in the back.
Oh, we're right up.
This Red Dog and Bergen's got with a team course. Talks about these.
Next year, student to law and we've been working in the while. Question I have is basically a earlier question is more of a statement. How can we talk about the new Civil Rights Act without talking about the Martinez case? The 76, it was basically still gaining, will knock the teeth out of the new Civil Rights Act. It allowed for tribal people not having due process. Any of the constitutional protections that average Joe Smith of small town USA has, any Native American is not entitled to those same constitutional protections. If we go on about it even more, by no due process, no applicable remedies, and the administrative, then my next move would be protecting yourself. Under all of law, if we try to protect ourselves, you would be incarcerated. So, picture of me and you no applicable remedies, no legal remedies, and if I try to protect myself, I'll be incarcerated. Then what's next? What's left? Maybe sunshine on Native Americans here and there, and they do get their time in work, and they get to stay where they need to stay. Well then, we have, beautiful. We'll get judges like Hagan High Hatfield out of Great Falls, throwing out 100-year sentences like he's retreat. So, the picture I'm painting here maybe a little too much reality. This is what we're seeing in content. Today, here, right now. We got candidates coming up, the candidates. It's not the reality. It's not what the I think it's 4 tribes that they got. I'm breaking it on this word. Probably jurisdiction on it. Violating the sister that was raped, murdered. They might be in our revenue. State. So, the state is a problem, but it's the morning, it's held in the head here. We have to talk about these. How can we talk about the Civil Rights Act without talking about Latinos? How can we talk about having an unbiased judgment when most of us aren't afforded because of constitutional protections that any average person would have? And you know what? I believe that I heard someone talk about how we go about thinking the way of seeing amendments to the Civil Rights Act. The Civil Rights Act, we ain't got any things. Not a long time ago. In the last 10 years. So I think we need to address the major things like staring at the right place before we go off on the other. Thank you.
Question here.
I think you both brought up some very good points with regard to tribal sovereignty. And the question is, obviously there's a tension between tribal sovereignty and giving deference to court decisions of tribal courts, and giving comity to another sovereign. And I guess this is more specific, addressed to Judge Morris. But when it comes to civil rights, I would have to agree with Professor Creel that there has to be, you cannot treat people differently simply because they're in a different sovereign status. Why wouldn't you use the supremacy clause then, the U.S. Constitution, to enforce those civil rights? I don't see that as a infringement on tribal sovereignty. As Professor Creel says, they've done what they're going to do, and if it's without counsel, federal courts should be held to a higher standard because that's the standard we're on.
I agree. The problem is, under the Supremacy Clause, you defer to the federal law. In this case, the federal law is the Indian Civil Rights Act, and it says you can have counsel if you can retain one. So we're stuck with what Congress has done back in 1968. And again, it's not a perfect template to overlay. And to follow up with what Professor Fletcher asked about juries, one more comment I'll say. It's not great for victims either, because I've had a number of jury trials where I go and thank the jury afterwards and appreciate their service, and it'll be a acquittal or a hung jury, and they shrug their shoulders, what do you expect? You know, up on those Indian people, it's just a mess up there. It'll find like it wasn't worth sorting out who was right with regard to the assault. Was it self-defense or not? Because it wasn't worth the trouble. You know, everybody was drunk. Don't worry about it. There's that problem as well. The defendants don't get the civil rights they deserve, and the victims don't get the day in court that they deserve. So I think it's a flawed system. When we get on the ground in a place like Montana and the distances we have to cover, it just doesn't work very well. And it's not the same kind of trials you see in state courts for similar crimes, where the jury comes from a local community, the officers who investigate are from local communities, they know people, they live there, they have connections, they can get information more easily. The victims live in those communities, they don't have to go off 4 hours to testify about what happened to them. It's not a great system, and we're patching it together because this is the way it was done back in 1883 when the Major Crimes Act was passed. Yes.
I'll add to that I think the denigration of tribal sovereignty happened with the Major Crimes Act, right? Taking out of the community where the crime happened and imposing a different system. The Indian Civil Rights Act could be seen as also a denigration of tribal sovereignty because it's imposing those different values of the adversary system on the tribe. And so that's where the idea of it's hurting tribal sovereignty comes from, because tribes were presupposed to be unfair, and so needed this Bill of Rights. But then when we look at what tribes are actually doing in their sovereign actions, sovereignty is what sovereignty does. And so if the tribe wants to have their convictions upheld in the court of public review, it's about fairness and what is fair for both sides.
I think the thing I want to conclude on, it's just from a teaching point of view. Mm-hmm. It's like, in teaching my Indian law students, you have to, it's kind of balancing realism and hope. For me, particularly as a non-native person, I can't be teaching Indian law that offers no hope, because I don't have the right to do that. And so from a teaching point of view, it's to try to point out these issues, but with a grain of hope that people who are trained, who have empathy, who know, who have skills, we can bring this to bear and kind of affect the status quo out there. Because I get a little nervous that, you know, if there's no hope, well, that's not helpful. And so for me, just as a teacher, it's important to balance, like, if you can, intense realism and hope. Saying, if you turn out and you take Indian law from anyone, including myself, you'll be better prepared to deal with these issues, which are not going to disappear. And so to me, there has to be a grain of hope from a teaching point of view, and also to believe in reason and skills, that this kind of conversation, to me, is a positive conversation, but I believe that there are optimal moments, and I worry a little bit that we're sliding under that optimal moment of hope and good things can happen into a certain kind of despair. And from a teaching point of view, I just say, fuck despair.
That concludes the first panel. Thank you, professors. Thank you, Morris.
Thank you.